How's it going, ladies and gentlemen? My name is Michael Thurville, and this is VEDA World News. You can catch this episode and more at VEDACOM.com with two M's. That is VEDACOMM.com. Now, today we have a very important guest here, Prosecutor, right here in Houston, Texas, and he is running for political office. Sir, your name?
Yes, sir. My name is Zach Gibson. I'm running for the First Court of Appeals, place number 3.
Okay. Now, let's talk a little bit about the Court of Appeals.
Okay.
What is that role? What does it consist of?
So the 1st and 14th Courts of Appeals it's a little unusual because they have what's called overlapping jurisdiction. So there are 10 counties. It includes Harris. The major counties are Harris, Galveston, Fort Bend, Waller, and then the smaller counties to the west. So it includes Washington, Austin, Colorado County, also includes Chambers County.
Wow, that is huge.
It is. It has a population, I believe, of 6.4 million people.
Okay. All right, so let's ask here. What made you run for this position? What was that inspiration? Where did it come from?
So let me just make a real quick disclaimer here at the first. I do work as a prosecutor at the Harris County DA's office. I'll be talking about that some in the interview about my legal experience, but I'm not here speaking on their behalf. I'm here as a candidate.
Understood.
That being said, the inspiration is I've been what they call an appellate prosecutor now for about 7 years. I've been a prosecutor for 10 years.
Okay.
And I practice in front of the courts of appeals on a daily basis. I just filed a brief on Monday in a case. Filed at 11:50 p.m. So sometimes
11:50 p.m.
Yep.
Are we talking about 1 minute before midnight? Or 1 minute before noon?
No. PM. It's like 11:55. So it was
Understood.
5 minutes before midnight. I wanted to get
Gotcha.
in on Monday, and anything 11:59 and below it's before the clock rolls over. So
Gotcha.
yeah. So no, I've done that for about a decade, and I've also seen the state of the judiciary here in Harris County and on the courts of appeals. And you know, when you're a very young lawyer, you think of judges and you look up to them and think, oh, they must all be so wise and know this. And then after you do it for a while, you realize, I could do better.
Really?
And so I want to make sure that we have, there are 2 seats on the First Court of Appeals still held by Democrats, and I'm running as a Republican. And I want to make sure that we get really good quality justices on the courts who will follow the law, write good opinions, etc. And so, so that's part of the reason why I am running.
Before we get in depth, what is it like standing in the courtroom arguing a case? And the reason why I'm asking this question, because so many people, when they go to a courtroom, it is so stressful for them. It is it's so full of tense. Mm-hmm. They're standing there. They don't know what's going on. Whatever they thought they were going to say, their minds are a complete blank. Like, what is that like for you as a prosecutor?
Well, for me personally, I still get nervous when I have to go to court. I
mean,
when I
nervous is a good thing.
Yeah, no, it is. I mean, it shows a level of respect and reverence for the process.
Okay.
When I was in the trial bureau, I was in court every single day that the courts were open. So basically 5 days a week.
Okay.
When you're trying a case, you're nervous because you've tried to prepare as much as you can. You've tried to have a jury selection questions specific to the case. I mean, there's a lot of work that goes into it. Mm-hmm. Then when you get in front of the appellate courts, you don't go to court as often. Oral argument is not terribly common, but it does happen, and the pressure's on. You're sitting there, you're arguing in front of usually 3 other attorneys, and it's a little nerve-wracking, but not in a bad way. I mean,
Gotcha.
You learn to get used to it.
Okay, so let's talk about law school.
Mm-hmm.
Which one did you attend, and how was it?
I did undergrad at Baylor, and then I went to law school at St. Mary's University in San Antonio.
Okay.
And I actually lived in San Antonio for about 7 years, and it was a good experience. I started off thinking, I'll probably do something with corporate business law. I want to make a lot of money, and then a major sort of fork in the road was I started reading all of the constitutional law cases and a lot of the criminal law cases and found them much more interesting. They're much. Party A is suing Party B over over the subclause of a particular contract, and it's kind of what it's sort of what it does.
I love the honesty. Thank you.
Whereas, when you get to criminal law, you get things like two guys were going to rob a bank and their car broke down, and this guy was a getaway driver. You have actual like real world facts, and they're somewhat interesting. Also, criminal law, everyone talks about it like it's its own area, and it certainly is, but there's a huge variety of things that you deal with. There's different types of crimes. There are different legal issues, whereas people that do civil work will get into like very, very narrow, areas. Like one of the jobs that I did for about 6 months as an attorney was called insurance subrogation for a lady that we basically handled car wrecks all day, every day.
Okay.
But we were just the property damage part of it. You could not do the personal injury part. Yeah.
Okay.
And so it was people fighting over $7,000, $10,000. It was all filed in JP courts. I mean, I learned a lot, but after a while it got rather monotonous.
Okay, JP courts. For those that are watching, they may not know the jargon.
Yeah, that's a justice court that handles very, very low dollar value civil lawsuits. And they also handle Class C tickets, so things like speeding tickets and stuff like that.
Understood. Now, we talked about law school, your experience there.
But
go ahead.
Before you get off of law school, the real fork is that I'd had that experience like the first 2 years. And then at the end of my second year, we would interview for doing the legal clinics.
Okay.
And so I'd taken, courses and stuff that had both civil and criminal and, other subjects. And I went and interviewed for the civil clinic, and I thought I did really well on the interview. I was like, I nailed that. And then I went and did an interview for the criminal clinic, and I thought, oh, that didn't go so well. So I was just assuming that if I got a call back, it would be for the civil.
Okay.
And then one day my phone rang, and it was like, we'd like for you to come work in the criminal clinic.
Wow.
And I was like, you sure you got the right person? But no, I did, and it was a very enjoyable experience.
Okay.
So yeah.
Okay, so now, again, coming out of law school, talk about law school, prosecutor here. What people want to know is, how will you serve them in the position that you're running for?
So the position I'm running for, like I say, is a 10-county area, and you sit in review of what the trial courts have done. So if you have a small business and you've been sued, and you think that the trial court got it wrong, they allowed the lawsuit to go forward when it shouldn't have, or whatever, you can bring that up, and then we will review it. Was it legally done properly?
How often does the trial courts get things wrong?
In civil, the reversal rate is higher. In criminal, most of them get affirmed. Now there is a reason for that, by the way, because in criminal, the state can rarely appeal. Okay. So there are cases where, acquittals occur because the state's evidence got suppressed incorrectly, but you can't appeal an acquittal because of the double jeopardy clause. So it's a sort of a one-way ratchet. In civil, both the defendant and the plaintiff can both appeal.
Understood.
There are states' appeals. I'm not saying that they never happen, but they're much more infrequent.
Gotcha.
So yeah, no, there is a not insubstantial number of times that the trial courts do get it wrong. In civil, there's more pretrial stuff that gets appealed, so it's more like piecemeal litigation. Okay,
before they even get to that escalation in points.
Correct. And sometimes those are dispositive. Like if somebody wins summary judgment and then that's affirmed on appeal, well, there's no need to have a full trial. So a lot of times the pretrial litigation can be dispositive in ways in the in the civil stuff.
Now, before we sat down and had this conversation, we talked about bail. Yeah. And we spoke with Republican candidate Oscar Gonzalez, and he was adamant about really changing the way bail and bail reform is being done here in Harris County, Houston to be more specific. What are your thoughts on that, and what could you do in your position to make things better?
Well, the courts of appeals do have a role in bail. That they have always been able to entertain appeals from defendants claiming their bond was set too high. Okay. In fact, I've handled some of those. I got a $900,000 bond affirmed on a man who was just very dangerous. I mean, he couldn't afford it, and affordability is definitely a
factor.
It's a factor, but it's not a dispositive one. If you're truly dangerous and you balance community safety, affordability, ties to the community, whether you're a flight risk, There's times where the amount of bond is set will not be something the person can afford, and that's
Just
not a bad thing.
okay, just to keep that dangerous person.
Correct.
Gotcha.
Correct.
In check.
Bail is a question of balancing certain policy considerations. Yes, the person is presumed innocent, but they also might be a danger. There are things where you balance. There are close cases, and then there are some easy cases where somebody should have a very high bond. So, in terms of what I would do as a judge, oh, and incidentally, the other thing I was going to bring up is that the courts of appeals may potentially have a more expanded role because now the state has the right to appeal the setting of a bond it feels is insufficient, i.e. too low.
Okay.
Procedurally, there's a very short timeline. I don't know how much this is going to be used going forward,
Okay.
but certainly the legislature has spoken to the fact that they want more review over what the trial courts do in setting bonds that
And
adequately
that was a
consider
very big deal
safety.
here in Houston and Harris County, where bail was set at a specific point. The person was able to make that bail, and then he goes out or she goes out, commits another heinous crime, oftentimes claiming the lives of people here. I mean, that is something to really consider. Is that something that you're really looking to be, how you say, aggressive on?
Well, I will aggressively follow the law. In other
Okay.
words, if you have somebody who is out on a bond that is set very, very low, and the average person would hear that and it just makes them laugh, like it's just farcically ridiculous. That means, putting aside the policy of it, that means the judge did not follow the law. So let
Okay.
me just make a couple points about bail. That these are things
Please.
that I hear that people have said. I've heard this in the news that are just legally untrue. So let me just start
Okay.
with something. Cash bail is constitutional. There were
Okay.
people going around in 2017, 18, and 19 saying things like, cash bail is unconstitutional. It violates equal protection. Nearly all of the federal courts that have looked at that have said the opposite. So the federal Constitution does not ban cash bail.
Okay.
It just doesn't. It's constitutional. In fact, the Constitution provides for it. It says in the Eighth Amendment that bail shall not be excessive, meaning
Correct.
that you're going to have cash bail. Anytime you're talking about excessiveness, you're dealing with cash money amounts, okay?
Right.
The British common law had it. The other thing, too, is that state law requires that community safety, something that weighs in favor of somebody not having a bond set that they can make, or not having a PR bond set, which is where the person doesn't have to pay any money at all. The judge shall consider that. Now, I'm only talking about what the law is. I mean, I have my
Correct.
own policy views, but that is currently what the law is that judges should be and are required to follow. If they don't do that, then they're not doing their job as judges.
Well, what are your policy views?
Well, I mean, I have my own subjective policy views as a prosecutor, and I'm a law and order guy. But let me just give you an example. We talked about the Constitution.
Okay.
The Constitution sets a floor, right? The
Correct.
states can't go below that.
this.
They can go above it. So there are some states, like for example, in New York and in also Illinois, where the legislature has abolished cash bail, and basically people get everyone gets a PR bond for certain categories of offenses.
Okay.
Now, if I were a judge and a prosecutor in those states, I might subjectively not think that's the right decision. However, as a judge, I would follow it, because as a judge, I have to follow the law. What I will not do, and where I'm absolutely adamant on this, is I will not use discretion that a judge has to then try to get around what the law is. If
All right.
people think cash bail, if they think it should be abolished, I respect that. Go to the legislature and get
All right,
them
and
to
you
do
get
that.
the laws, you get to pass, and then
Right,
boom, it's
exactly.
formal.
Yes. If people think that in all misdemeanors, for example, everybody should be out on a $100 PR bond, that's fine. I mean, I wouldn't agree with it, but
Right.
but my point is, speaking as a judge, the thing that has upset me about some of the stuff that's occurred with bonds in Harris County, yes, as a voter, I have certain views, but as an attorney who understands what judges should do, it's upset me for the secondary reason, which is why I am running, which is you put your hand on a Bible or the Constitution, whatever, and you swear an oath to uphold the law as a judge, you have to do that. If you don't
Yes.
think you can do it, if you
Then that position may not be for that particular individual.
that's exactly right. Yes, it's true that in Texas we elect judges as opposed to appointing them, but the role of a judge is much more limited than that of a legislator or,
Okay.
or for example, a governor. For example, I cannot endorse candidates for office because I'm supposed to be seen as neutral and
Correct.
not affiliated. And I don't. I stay out of what I think the law ought to be. But I do have a very strong view that judges should follow what the law is.
Okay, and here's the deal. Subject to interpretation. I was thinking about this a couple of days ago, and I say to myself, why are we in 2025 going with that subject of interpretation? Why not just simply go with the law as it is written?
Well, I have some guesses as to why that might be. Part of the thing that started the issue of bail reform was that it would be like if it stops raining and somebody gets rid of their umbrella. Like people take for granted certain things.
Yes,
because so
we
like
do.
by like 2014 or 2015, 2016 in that area, crime was at like a 30 or 40-year low. And so people could start talking about the things in the criminal justice system that they did or didn't like. And there's always room for reform.
Correct.
But the people neglected the fact that maybe some of the tough on crime policies were what caused crime to fall for 30 years. You abolish those, well, crime's going to go back up.
Correct, because you had something in place that was working. It takes a little bit of time for it to catch up in the system.
Right. Now, in the question of some of the other states that have done like the cash bail stuff by statute, in those states, you can disagree with that. And again, I express no
understood.
views on what
And
the law ought to be.
Let me first put a disclaimer here.
Yeah.
Here at VEDA World News, it is uncensored.
No, I got
You don't have to,
No, I'm just saying that, like, in
Understood.
terms of, like, those states that have done that, if I were a voter or legislator, I might not support those. However, as a judge, I would follow it because if you're going to change the law, that's the way to do it for two reasons. Number one, the legislature has that responsibility. But number
Correct.
two, it also allows for democratic correction in the other way. If people take it too far, because in some of these states, the public has not liked certain aspects of this, they can go down to their legislator and say, hey, I think you've gone too far, let's rein it back in. Whenever judges do it, if the judges use, for example, they say, well, the Constitution requires this, well, there can be no democratic correction for that.
Correct.
So that's why as a judge, as a judicial candidate, my views on bond are a little bit more limited than someone like, for example, your friend Oscar, who sat here, and he talked about it much more broadly, like what the law
Yes.
ought to be. I may personally share some of those, but as a judicial candidate, only thing I care about is, are the judges following the law?
Right. Are they carrying it out as it is written?
Right, and unlike some of these other states, Texas has not abolished cash bail. Texas has cash bail. Cash bail is the system presumed by the legislature. It's article, for any legal nerds out there, it's Article 1715 of the Code of Criminal Procedure, and it lists the factors, and it says judges shall consider community safety. It is not optional. It's not something you can pray about and think about. No, you have to do it.
Well, let's ask a quick question here. With crime, is crime going down in Houston, Texas, Harris County? Is it going down?
That I'm not going to speak about for two
Okay.
reasons. Number one, that's kind of outside the judicial. I mean, because obviously I would handle the cases in front of me. Number
Correct.
one, and number two, crime stats always have to be revised going past, in the sort of past tense. So if
Okay.
anyone that looks at like very recent crime stats, I've never found those very
Reliable?
well. I've never found them very persuasive because they have to
Okay.
be revised, they have to be weighted, they have to be this and that. So whether crime is going up or down, I express no view on that.
Okay. Are you able to speak about the controversy between Texas state law and, ICE with immigration? Are you able to speak on that?
Well, no, for the
Okay.
main reason that immigration law, so the courts are courts of general jurisdiction. We handle a lot of areas of the law, but ICE and immigration law is purely federal. So that would not,
Okay.
that would not
Not
come
be
before me. And also ICE answers to like a higher federal authority. So whether what they're doing is legal or not is usually up to federal courts.
Because that's
and
what a
stuff.
lot of people are afraid of, especially those that may be immigrants from other countries. They're a lot of times scared to come outside here in Harris County. One guy said that he was scared to go to the laundromat,
Yeah.
know. So that was a real big hot topic that I just had to kind of, bring to your attention if you felt like you want to answer that or not. Criminal code. What about the jail system that's happening right here in Harris County?
Well, outside of some of like the bail factors, again, that's more up to the political branches. But
Okay.
and those are purely political decisions. How much money do you want to spend? How much do you want to do this? How much do you want to do that? I mean, I've saw the interview with your friend Oscar and some of the other candidates who've talked about it. I refer people to those. I mean, they can
Okay.
vote. People can vote how they think they should. And I encourage them. Watch the interviews, look at the candidates, see what positions they're taking. Vote how you think they should.
What are the three things that are important to you if you were elected to office?
Well, number one would be specifically judges that consider community safety in bonds. And I say that as a matter of public messaging because we have to be elected, and that's something that people really, really care about. I mean, there are other areas where judges should follow the law, in the family code and things, but that's one that's really pressing. The second thing, and it sort of ties in generally with the first, is judges have to follow the law, not put their own policy preferences on it. One way
Do you
or the
feel
other.
like that's happening more often than not, or that's just something?
On the bond issue, it totally happened.
Okay.
There are other areas where I have suspected it. Obviously, judges do not come out and say, well, I am not following the law.
Correct.
I have got, let me just tell you about a real case. There was one where there was a case reversed for the punishment phase, claiming that evidence was improperly admitted. And it was a 5-4 decision in the local court, and I thought it was wrong. I took it to Austin and got it reinstated 9-0. And in the opinion written below, I could see there were some areas where perhaps the judges, and I'm inferring this, but perhaps the justices didn't agree with some of what the Court of Criminal Appeals had done regarding the confrontation clause.
Okay.
And so they were trying to find another provision where they thought this guy should get relief, and in the process screwed up an area of evidence law. Now I got it. The Court of Criminal Appeals reversed that, and then they had the final say on it. But there have been times where I have suspected it. In the issue of the bond, in the particular bond controversy, I haven't just suspected it, I've known it, because people will say things very, very confidently to the media and to television that, cash bail is unconstitutional.
Wow.
And I'll be looking at a federal court opinion saying the opposite. And I'm like,
Where does this misconception come from? Is it social media? What's happening?
no, well, look, the Constitution is like any other area of the law. It has people's different policy preferences, what they think the law ought to be. If somebody comes out and says, I think cash bail should be held unconstitutional, they're entitled to that opinion.
Correct.
I do know. Or if they think cash bail is unfair, if all the arguments that you heard, I say take it to the legislature. But as a matter of constitutional law, because it isn't just what judges think locally, like there are areas of federal constitutional law that have been interpreted by the Supreme Court, by the federal courts of appeals.
Okay.
Lower court judges running for a district court and a county court bench, they're pretty far down the totem pole.
This is true. Yes, it
in
is.
terms of the judicial pecking order. So like there are certain constitutional questions where they may have their own view and they're entitled to it, but they have to follow what the higher courts have said.
Correct.
That's what they call, for the legal nerds out there, vertical stare decisis. So you have to follow what your judges, what your taskmasters from above say.
Okay. I love the way you put that, and that's like a real legal term. We appreciate that.
Yeah, no, and look, there are areas I'm not going to talk about them publicly,
Understood.
but there are areas where I look at what the U.S. Supreme Court or what the CCA has done, and I may subjectively think I wouldn't have done that, but if I become a judge, I have to follow it. Yes, I have to follow it. There are some famous cases that have resulted in reversals where the lower court judge at the intermediate level, there's one I can think of in particular, I think it was a case called Paulson. And the lower court judge just thought that an earlier CCA case, that's the Court of Criminal Appeals in Austin, was just wrong. But he knew he had to follow it. So he wrote an opinion saying, I think this is wrong, but I will follow it and we will reverse this conviction. The CCA granted review and ended up overruling the prior case, and so the judge below had the last laugh. But it's a case where there are times where you'll disagree with things, but you have to follow what the higher courts have said, even if you don't like it.
What is the penalty for a judge who fails to adhere to what the higher ups are saying?
Well, that's a difficult question. If they just didn't follow the law, and that's all because judges make mistakes. Everyone makes mistakes, and there are tough, close cases. I'm not saying that they're not. Yeah, but it's usually just being reversed by a higher court. If you have a reason to suspect bad faith, then you can take them to judicial grievance committee and things. But usually the judges are presumed to act in good faith. Yeah, that may not always be true, but it's certainly the presumption. And I think most judges do work very hard. To try to get the right result. But as a matter of that, no, you're required to follow it, even if you don't like it. Trying to think. In terms of we talked about the Constitution and it's setting a floor. So there are examples in Texas where we just give criminal defendants, as a matter of statute, more protection than the Constitution requires. States are always free to do that, but it's the legislature who should do it. Unless it's a matter of common law or something.
Understood. Well, what is the second critical point that you would focus on? Well,
following the law, the second is have judges who have the experience, which again, I have by far the most experience in appellate litigation of anyone in the Republican primary. But it's more also having judges that understand, or justices I should say in this case, that when you get to the appellate level, you have two things going on. So in the trial court, a lot of trial court attorneys who run for the courts of appeals will talk about, I want to get the case right in front of me. And I mean, you certainly should. But at the appellate level, you have two considerations. Number one, applying the law in this case, but also you have to write an opinion that sets forth what the law is, explains how it applies, and then you're creating something that is going to bind you going forward.
Okay.
And in fact, at the appellate level, frequently the precedent that the court is setting is much more important than any result in one individual case. I mean, think of all the famous Supreme Court cases, Brown versus Board of Education, Miranda versus Arizona, Roe versus Wade. These all had individual litigants with their own stories, with their own legal issues. But these cases were much more important because of what it set going forward. And so it's important for judges to have judges who will write an opinion that it says what the law is, doesn't go into things they don't need to decide. Because when you have a case and you engage what they call dictum, which is Latin for a thing said in passing, where judges will kind of say more than they need to. And in this particular case, that language isn't really problematic. But you have the next case. This language that you said may actually not cause a very good result in this case.
Gotcha.
So you want to make sure that you decide cases in a way that set good precedent going forward, because you're deciding, so $6.4 million for the First and 14th Courts of Appeals. If I screw up a matter of property law in the appellate court and set precedent, I haven't just screwed it up between these two people. I've screwed it up for 6.4 million people who will then have to rely on what the property law is.
Right, they will go back and look at that and check it.
Right, wills, contracts, etc. will be done. So that's why it's especially for certain areas of the law, like property law, like constitutional law, you really do need to work hard to get it right.
Understood. What would be the third critical thing that you would either change or administer?
Well, I think I said three. The bail, not ideology, and then the third was make sure you get the law right.
Okay.
Fourth would just be work hard but work diligently. Like the courts of appeals justices read and write all the time.
Okay.
And that's what I do currently. I mean, I'm one of the few people that enjoy sitting in a room, reading records, getting into Westlaw, researching old cases.
You're not the only one. I am a journalist, my dear sir. I love to read and write in a room by myself, too.
Yes, it is. Well, But I mean, mine is certainly a much more of a legal nerd side.
Right.
Like I know when there's a brief on my website people can read at zacforjustice.com where I actually wanted to know what was the practice of hearsay in the sentencing phase at common law. And I went back and I had to pull cases from the English Reporter, which I'd never done
Really?
before, from the late 18th century. I found this interesting and fascinating. I told other people about it and they would just look at me and smile.
Like
And
how
that
does that make you feel? Like you have to go back that far to answer or find a solution for something that's happening in 2025 or even in the early 2000s, like really that far.
Well, in that particular case, I did it to really make a point because all the federal courts had basically held that so this was about whether, let me just back up. The Sixth Amendment, for example, says that you shall be confronted with the witnesses against you. And so I thought, well, what does that mean? Well, all the federal courts have held that it does not apply during what's called the sentencing phase.
Okay.
But the Texas state authority on it there wasn't a ton of it, and it's an issue that I think Texas struggles with because we apply the rules of evidence in our sentencing phase.
Okay.
See, I said earlier that states can always give more than the Constitution. So if you go down to federal court, you have the rules against hearsay and these things all apply during the guilt innocence phase, whether you did or did not commit the crime. When you get to the sentencing phase, you can have affidavits, police reports, just introduced into evidence. You're right. And so we don't do that. We're used to the sentencing phase looking a lot more like the guilt innocence phase. But the Constitution does not require that, was my only point. And so I went back and pulled the cases, and I was like, no, these cases are right. Here's what they did at common law. And, and that's what they, I think the British use, we have what's called a PSI, a pre-sentence investigation. Theirs is called, I think, a pre-sentence report. But it's just rank hearsay. Words. Yeah, it's just rank hearsay. So yeah, no, that was fun. I enjoyed doing that. You have to pace yourself. You have to work on a thing, put it aside, and then come back to it because you're always going to be drinking from a fire hose. I mean, you're always going to have a ton of briefs in front of you, a lot of stuff to read. A lot of them will be difficult questions where you want to take enough time to get the answer right because, like I said earlier, you don't want to screw something up. But you also have to get it done, and so it's a sort of balancing act between the trains need to run on time, but the trains need to run to the right destination.
Correct.
Because if they don't, that'll cause a lot more problems down the road. Yeah.
Oh, wow.
Or down the line, I should say, to keep the analogy.
I love the fact that, yes, you're an attorney, but you're also a prosecutor and you're also a historian.
Well, actually, yes, I did. My undergrad degree was in.
Really?
Yeah, it is. I got a history degree at the Baylor, and so I've always enjoyed sort of following British history. So getting to read the old British cases was somewhat fun for that aspect of it. That's true. It was very sad and ironic. I found a case. I remember the day that the late Queen passed away in 2022. And I was looking up cases about judicial notice, and it was the day that she passed away, and I found a very old British case saying that courts may take judicial notice of the day the monarch dies. It was just a very sort of ironic, coincidence. But anyway.
No, you're good. You're good. What are your thoughts? And I don't know if this is in your lane or not. Just let me know.
Okay.
What are your thoughts on Terry versus Ohio? Is it still relevant for 2025?
Well, it's still relevant. It gets applied all the time. I mean, I've had cases that have hinged on Terry versus Ohio.
Okay.
Obviously, I've read arguments that Terry was wrong. I may not find them very persuasive, but Terry versus Ohio stays until the Supreme Court says otherwise. I mean, that's the short answer. In terms of is it relevant, yes, it is relevant. It matters a lot simply because Terry is dealing with this issue of, I'm going to call it the middle ground. So you have somebody who's a free citizen roaming around. He can go where he wants, unless he's trespassing or something.
Okay.
And the police don't have the authority to detain him. I mean, the police can talk to him voluntarily, but he's free to leave. Then there's a full custodial arrest where you are either under arrest or you are detained to the point that it's the equivalent of a custodial arrest.
Okay.
But a lot of police interactions with citizens deal with this middle ground. Like when you're pulled over for a ticket, if you're driving your car down the road, you're not under arrest. In fact, if all he does is write you a ticket, you're not even going to be under arrest.
Correct.
Those the Terry area is actually what a lot of interactions that people have with the police are in that area. Now I know Terry also deals with the other thing about when they can pat you down, which is
Correct.
a separate thing. But a lot of the so-called detention cases, a lot of police interactions are in that category actually.
Okay.
They may not get to a full arrest. Obviously, if we're handling it on appeal, it usually has. But it doesn't always. A lot of times the police will investigate and say, yeah, this is not worth my while, or I don't think there's been a crime here, I'm only going to write you a ticket, and then you're just free to go.
And on reasonable suspicion?
Yeah. It's based on reasonable suspicion. To make a full custodial arrest, the current law is you have to have probable cause. To detain somebody for a so-called a Terry stop is just reasonable suspicion. It's a lower level, but I think part of the justification for that is that it's a lower level of government intrusion. They're not taking you all the way downtown, and
Right.
So
and the reason why I brought that up is because so many people, when they get stopped by the law enforcement, they don't know what's happening. They think they may know, but they don't know what's happening, and they don't know Terry versus Ohio. They don't understand that upon ask for ID that you must provide your ID to a law enforcement officer. They'll fight the officer and oftentimes make that situation bigger, way bigger than what it's supposed to be. And they end up with all kinds of sorts and charges and everything like that. So I'm glad you were able to, shed some light on that and talk about that for people.
Yeah, well, I mean, it's a situation where, like I say, the Supreme Court is always free to revisit what it said. But Terry versus Ohio, as of today in 2025, is still good law.
Okay.
I would be highly surprised if they ever changed it. But
Wow.
but if they did, then we would follow that. But as of right now, yes, Terry is valid law. It's not an aberration. So
Okay.
Anyway.
Why should voters vote for you? You're a Republican candidate in what I like to call a blue pocket.
Well, I'm a Republican candidate in a Harris County, without getting too much into partisan politics,
understood.
in judicial races has become very, very purple. So let me just use myself. Let me use myself as an example. In 2022, I was one of the Republican candidates for the countywide benches.
Okay.
And when I signed up, I thought, I knew people in the Republican Party, and I thought, well, I'll sign up and put my name down. I thought, I don't have a chance. Then we start campaigning and talking about we need judges that follow the law and all this, and I could tell it was resonating. The result in 2022 was that most of the Republican judges lost, but by very small amounts. So, for example, Greg Abbott got 490,000 votes in Harris County and 44-point-something% of the vote. I was down ballot and got 521,000 votes.
Wow.
So I got 31,000 more votes than the sitting governor, and I got 49.32% of the vote.
Sounds like you need to be running for governor.
Well, no, I don't. First of all, I could not imagine running a race over 10 counties is a lot.
It is.
I couldn't imagine doing it statewide. It would just be incredible. But anyway, and a lot of the other Republicans who ran, they might not have won, but they did much, much, much better. In the last election, and I think the margin between Beto and Greg Abbott in that race was about 100,000 votes.
Okay.
And about a 10-point spread. Fast forward to 2024, and so the Republicans didn't fill all the spots in 2024 because a lot of people thought there was absolutely no hope.
Okay.
I think the majority of Republicans who actually ran, who were on the ballot in the countywide races, I think most of them won. And Trump got over 46% of the vote, and the difference between him and Kamala Harris was 50,000 votes.
Okay.
So people that just write off Harris County as blue or it's this or that, it certainly does lean that way. But also over a 10-county area, you can make it up in other counties. So let's say you're pulling 49% of the vote in Harris County. The other counties tend to be very, very red.
Gotcha.
So
it kind of balances itself out.
It
in
does.
A way.
It does. The first and 14th courts lean Republican. Now, Democrats can win. In 2018, when they had that big Beto surge, and this was before the bond issue became controversial, so the judges down ballot were doing very, very badly as well. And I mean, Beto really blew it out of the water in Harris County. That was enough to tilt the courts of appeals races by about 50,000 votes.
Okay.
But I mean, still, that's not a blowout over a 10-county area. And then in 2020, the races were unbelievably close. The two Republicans won by a hair on the 14th court, and the two Democrats won by a hair on the first court. Actually, one of the ones I'm running against won that election. To show you how close those races were, Tracy Christopher, she was running for the Chief Justice spot, and she won it. Out of 2.2 million votes cast, she won it by 1,000 votes. It was like 50.0001 to 49.9. It was very, very, very close.
That is closer than close.
It is very close. Now, the last two times, because we've had a lot of down ballot support for Republicans, it's benefited the courts of appeals candidate. Anything with judge or justice by it, Republicans have been doing better. We've won the courts of appeals races fairly comfortably. This race, again, predicting what's going to happen in politics is, I know. Yeah, it's very, very hard to know. I do think that the courts of appeals races would be at least close, even if it's a very, very good Democratic year.
Okay.
As for why they should vote for me, let me address the main election coming up, which is the Republican primary. I by far have the most experience with appellate stuff. And also, this is something that's going to matter to Republican voters a lot. I'm a law and order Republican.
Okay.
Two of my, and I have a real track record for saying that. Anybody running in a Republican primary would be insane not to come out and say, I'm a law and order Republican. I mean, you're committing political malpractice if you don't. Okay. However, the two people I'm running, the two main candidates, there's a third one who is sort of jumped in. She hasn't filed. I don't know if she will, but there are four. But the two main ones I have, one practices IP litigation, so he handles patent law, and the other is a family law attorney. I get along with them both very well. I'm at events with them all the time, so I have to be nice. But I mean, you can say you're a law and order Republican, and you very well may be. I gotta say, go up to the average voter in Harris County who is splitting their ticket to help put Republicans all over the top and say, I know the most about IP litigation, or I know the most about the family code. Or you go up and say, I'm a law and order guy, and here are the cases where I have a real track record of
It makes a difference.
Exactly, because they know I'm the real deal.
Correct. And
other people, if you don't have the real life experience, the other thing is the other candidates running against me don't have the amount of appellate experience. It isn't just about, as a prosecutor, I handle more criminal cases. Although criminal is an important part of the first court's docket. It's like 30-some-odd% of the pending cases. But I was told recently that it's about 40% of the opinions issued on the merits. Because, some cases go away, they're settled, or the case gets dismissed.
Correct.
It's about 40% of the opinions on the merits. And in an area where people care about that I think should tell you what the voters care about. So that's why you should vote for me. Number two, if you put me on the court, I'm going to just follow the law. And so whoever has the best argument.
A lot of people can appreciate that.
Yeah, I'm just going to follow the law. There will be times where the defendant should win. And that's okay. I mean, it's might not be my subjectively favorite result or whatever, but it's fine. If he has the best argument, if the law wasn't followed, fine, we'll reverse the conviction. If it calls for it. I mean, a lot of the things where criminal defendants complain about things, there'll be something that might be technically wrong, but it's going to be clearly harmless. So not everything requires a reversal, but in some cases I will. Anybody, here's what I tell voters. My goal is to act like I'm a judge and a justice in a court, and that any member of the public, the plaintiff, if it's a civil case, the state in a criminal case, the defendant, criminal or civil, crime victims, police officers, John Q. citizen, anybody should be able to come into court and see that the people there are respecting the law, that they take the people's business seriously, and that they want to do a good job. It doesn't mean you'll always be right, and that no one can be 100% correct. Right. But you should be working hard to do the very best for the people that put you there, because it is an honor to serve the people. It really is. It might not always be lucrative, but it is a big honor to be able to do the people's business.
This was exceptionally well said. Where can people find you?
So they can go to zachforjustice.com, and if you go there, you'll find a link to my Facebook page. You'll find a link to some of my writing samples. You can send me an email. I'm happy to talk with people about things. Obviously, like in this interview, I can't give my views on policy, but I can say I will follow the law and I will do what it says, and I always will if you elect me.
I believe people can really honor and respect that in these troubling times with, being subject to interpretation, kind of feel like they're being misled in some places, some cases. Thank you, my dear sir.
Well, thank you for having me.
It's an absolute pleasure.
It's been a pleasure to be here.
My name is Michael Thurville, photojournalist and sociologist here at VEDA World News. You can catch this episode and more at vedacom.com with 2 M's. That is VEDACOMM.com. See you soon.